We are going to talk about unlimited term contracts, but we're going to talk about a particular change to the law, which is the amendment to the Labour Contract Act. And that was, it was meant to remedy some of the inequalities between different groups of workers, in particular workers on limited term, various types of limited term contracts. And just to distinguish between what I was talking about with the Labour Standards Law, the Labour Contract Law is civil law. So there's no office, well there is an office you can go to, and we'll maybe talk a little bit about that later on. But there's no office that you can go to with legal force to go in and stop an abuse with this case. You rely on court cases basically to do that. And guidance from the Labour Bureau. The Labour Bureau can give guidance and advice and even mediation, but it can't force an employer to work properly in this way. Okay, now I'd like you to look at the first paragraph. It says, simply put, you can apply for an unlimited contract on the first day of your 6th year of employment. Your employer must accept the application and must give you an unlimited term contract after the current contract expires. That's simply put. The reality is it's a little bit more complicated than that. This is true if you're on a 1-year contract, which I know a lot of people are. A 1-year contract starting in April, this is true. So you'll have, so you'll go through those years, and after that you'll get the indefinite contract. After 5 years, you qualify to put in a request. So that will be in your 6th year. And then the next year, the beginning of the next contract would be an indefinite contract. Okay. In principle, with the same conditions as you had in the contract before. However, that's with a 1-year contract starting in April. I'd like you to look at the charts above, and in particular have a look at the small print on the left-hand side. And it says, from the start of the contract on or after April the 1st, 2013. Well, say you have a contract, we could use the board for this, but we have not got any marker pens. But say you've got a 3-year contract that started in July 2012. Okay, so it wouldn't be, now I'm going to do the difficult math here, that contract wouldn't end until 3 years later, which would be 2015, July 2015. So your 5 years wouldn't be from 2013, but would be from July 2050. So you can see that it's possible there. In theory, the worst case scenario, it could be 2020 before, you know, even though you've been continuously employed since 2013, it could be 2020 before you qualify. But that's the cases where I've come across in education that are like this, because most Japanese schools, if you've got limited term contracts of 1 year, starting in April, finishing at the end of March, it's normally, most of them are like this, but international schools are the exception, where you've got 2 and 3 year contracts, and the start and finish date is July, August. So I think the end of July is the end of the year. Is it end of July or end of June? I can't remember now, but they're a little bit complicated because of this. And be careful on this. If in doubt, the other one was Temple University that actually had contracts illegal under the Labour Standards Law for 5 years. That's don't patter. I went to Temple too. But basically, so there are a few exceptions like that, and kind of tricky questions. Somebody with a 5-year contract that shouldn't have a 5-year contract. I'm not even going to try to start today to answer what should happen in that case, but it should have been a 3-year contract, therefore you should have had maybe another 3-year contract. I don't know, it's a difficult one. And but basically for most of you that will be on those 1-year contracts, it will be You should have, from April 2018, if you were there before 2013, you should have qualified for that indefinite contract. Now, in principle, it's the same pay and conditions, in principle. So it raises the point about what happens if they, say you're a part-time teacher, and they cut your classes, and you pay by classes. Could they do that? What do people think?
Yes, probably.
Yeah, we don't know. In theory, they shouldn't be able to do that because that would actually change the pay. So in theory, they couldn't. But if the number of classes had varied in the past, we don't know. And there, as far as I don't know of any legal precedents right now. So this is a new law, and of course, laws don't just exist on paper; they exist in how judges interpret them. So we don't actually know 100% on that.
I assume the contract, like all my contracts pay, like it's written per class rather than
Yes.
number of classes.
Yeah. So therefore, your contract hasn't changed if they cut your class. But on the other hand, your pay has changed, and there's a substantial argument there that it's not the same contract. But we think there is a case that they couldn't. There's a case that they couldn't do that in the first year, the first contract. But in the future, we think it's highly unlikely that courts would interpret it as you could have no change at all, because even with an indefinite full-time contract, if the employer has reasons and legally reasonable grounds for doing it, well, they could probably do it. Even with we've had cases with bonus that's written in, bonus paid to full-time permanent employees, and all of a sudden the employer has decided to cut that bonus. In most court cases, they've been allowed to do that because they had economic grounds for doing so. They would not do it very well, and that was deemed to be reasonable. However, one of my employers did it to their tenured teachers. They just cut the bonus massively, Ritsumeikan University. And the in-house union took them to court, and they won. And the reason that they won is because Ritsumeikan University had no need to cut the bonus. It was raking in money at a massive rate. And it was just, they wanted more money to play with their projects and the things that the people at the top dream of doing, and they were trying to cut the teachers' bonuses to do it. But because they didn't have legally reasonable grounds there for it, or educational grounds, if they had, for a lot of these changes, for example, if they changed the curriculum and you're a teacher of Portuguese and they suddenly decide they're not going to teach Portuguese anymore because they've taken a reasonable educational decision, say there were no students who wanted to learn Portuguese, came along in the last year or something like that, then undoubtedly they will be able to cut your classes. I don't think there's much doubt about that. Especially, maybe not the first year, but in the future. It doesn't mean that you're locked into the same number of classes forever because you've got this indefinite contract. And we should be careful about that. So some of the members of our union of companies said, well, why are we pushing for these indefinite contracts? They're useless. They don't guarantee my income because I'm a part-time teacher. I think that's very wrong, because right now that you're much better on these indefinite contracts, and I'll explain why. Because right now, with the one-year contracts, we said with university teachers, probably with high school teachers as well, who are paid by the class, there's court decisions, Aja Daigaku, Japan, dating back to the 1970s, that ruled Hindi teachers who had been at the university for 20 years were just dismissed. And the courts ruled that they didn't have legally reasonable expectation of renewal in their contracts because they were part-time. Now, that's a very dated legal judgment, and our lawyers have told us that they think the time is right to overturn that judgment, that far more people are part-time now. It's a different economy, different views there. But still, those judgments stand right now. So before, say they non-renew you, your first step, you have to show that you have a legally reasonable expectation of renewal. And then there are this case law that says, oh, if you're part-timer at university, yes, that's legally reasonable to do it. So you have to jump that hurdle before you can actually look at the grounds for dismissal. And basically, if you have the indefinite contract, you don't have that business of expectation. You know, obviously you have that expectation. And for example, other things, if they needed to get rid of people, say the student enrollment is right down, there's a kind of hierarchy of that they can get rid of people on that. So it's always been accepted that you could get rid of, it's reasonable to dismiss part-timers before full-timers, and last of all, the regular workers or semi. I mean, I don't like the system, but the court decisions are that there's that hierarchy. You get rid of the least secure, the people on the indefinite contracts first. And if courts hold a similar hierarchy, then they have to get rid, if it's a choice between people on one-year contracts or the people on the indefinite contracts, they have to get rid of the people on the one-year contracts first. So, for a number of reasons, this does give you a lot more security. So, don't be put off if your employer introduces a 60-year retirement age for, yeah, we've got somebody in the audience there that's happened to. If you take the indefinite contract, there's a 60-year retirement age. Whereas if you stay on the one-year contract, there's no retirement age. Don't be fooled by this, because they have a statutory duty to keep you employed till 65 anyway. And why do they want you to do this? Why do they want you to stay on the one-year contract? The fact is, it's much easier to get rid of you than on the indefinite contract. So even in those cases, I mean, take advice on it, but I would strongly advise people to go for the indefinite contract thing, to ask for the.
I also had the. I was told by Osaka Immigration that I will never get Educan if I don't have, like, because I'm on one-year contracts. They said just like, no, 1-year contract, 1-year visa, you will never get Educan.
I got a 3-year visa on like a collection of part-time contracts last year.
Really?
I was originally on a spousal visa, but I got Educan while I was on just.
I know, it's just with tons of staff, they just said, nah,
I
no
haven't got-
chance,
I
unless you're
haven't
on
got-
unlimited
I haven't
contract.
got Educan, but I've got 3-year visas on 1-year contracts many times.
Really?
So the visa length doesn't have anything to do with the contract length.
Okay.
If you've been working on 1-year contracts and you've been in Japan for 20 years and it looks like you're going to stay, then
Your taxes and bank account probably go a long way.
Because lots of people are employed for 20 years on 1-year contracts and they're constantly renewed. 1 year doesn't mean you're leaving after a year.
No, it was just what staff told me.
Nick's right
on-
on- Nick's right on one thing, it does affect other things, like if you buy an apartment or something like that, you'll find it far more difficult to get a housing loan if you haven't got an indefinite contract. I can only find one bank, and it wasn't the Labour Bank, that would give me a housing loan because I had a contract limit. I was full-time, but I was on a, can't remember whether it was 5 years or 3 years limit that I was on. It was a 3-year contract actually, at high school at the time. Okay, now let's go on. Have I dealt with everything here? Okay, I want to deal with an exception that will mainly affect university teachers. And that is, there is an exception to this 5-year limit. It will apply to most workers in education, that after the 5 years, after your 5 years after your first contract, after 2013. And that exception is what's been called the 10-year exception, and it's for workers involved in research. There are 2 separate laws. Workers involved in research or have a substantial research element, or the people I mentioned earlier on, these strange people, Ninkitsuki or Ninkise, who can have up to a 5-year contract, who are supposed to be linked to certain projects or special projects that universities are doing. So these laws only apply to university teachers. Now the problem is right now, most of the major private universities in this area are claiming that all of their part-timers fall into one of these categories. Not that these part-timers have never been told that they're Ninki-ho or Ninkitsuki. They, some of the places actually tell people, no, we don't expect you to research. We don't give any research funds or anything like that. But they're claiming that all of their part-timers are Ninkitsuki or researchers or something like that. Now, Toshi's done a lot of hard work talking to the Education Ministry, Toshi and Dennis and others, and we've been negotiating with the universities. Basically, this is completely wrong, and we found this after long negotiations with Kangaku. Their thinking was that Ninki was any worker on a limited term contract. Well, this is their argument. I don't think they really believe this. In fact, the personnel department said no, they actually accept our view that they're wrong, but it's a lot of work to change it. That's what the guy from the personnel department actually told us there. But basically, Ninki should be special groups of teachers who are employed linked to a certain project, which is not going to continue indefinitely. And that's why they have an exception to the 3-year thing under the labour contract law, because originally they were tied to 5-year contracts. Very often, the original Ninkitsuki were full-time teachers with 5-year contract renewable once there, and they're supposed to be associate professor level or assistant. Associate professor level can mean all sorts of things at different places. I know Doshisha, after so many years, their part-time teachers become associate professors or something like that. It doesn't really get any more money or anything like that. So it's a little bit blurred, but we believe that most of the university part-timers do not meet the requirements for this 10-year exception. The only problem is, how do you fight that? Well, if they non-renew one of our members who's put in a claim for an indefinite contract, then we'll fight it. We can take it to court. We'll use the civil court law. Universities like Osaka City University, where you're at, Nick, we try and push them through negotiation. At Kangaku, again, we're negotiating with them. We're trying to force them, and we're going to try and involve the Labour Ministry and people in like that. They don't have the power to enforce, but they can advise. And where the administration is wobbling, we get the Labour Ministry people in, giving them guidance. We may be able to get rid of the 10-year limit. I think it's going to go eventually. It's something that the universities have used, and it's wrong-headed. Okay, so that's a particular exception given to universities. Now, there's a few other tricks that they've tried. One is introducing a limit on renewals, say a 5-year limit on renewals, so you never reach the 5 years. What do people think about that?
I think it's been on almost every contract I've ever seen in my life.
The 5-year limit, yeah. Yeah, it's like part-timers don't seem to have those limits. I'm on a 5-year contract a 1-year contract with 4 renewals, so I'm finishing in April in my case. But so for full-time university teaching, yeah, we have that system, and a lot of other people have that system. But a lot of part-timers don't. There's no limit, and there's never been a limit there. So management have tried at some places to introduce a limit. Sometimes they say you've got to take a 6-month break, because in order to break the 5 years, you have to be out of employment for 6 months. If they just end your contract 1 day early and say, no, you don't qualify because there's a day here, they can't do that. It has to be at least a 6-month break in order for you not to get the 5 years.
Are they legally allowed to sort of just write into your contract, this is your last contract, or all the legalese, and then you just,
well, there's nothing.
like most of us.
There's nothing that stops them from writing what they want into the contract, but whether it has any legal effect is another matter. And in this case, there were notes, like most laws, the civil servants wrote notes on implementation of the tsutats in Japanese. And this law, it specifically mentions that I think the law passed in August 2012, and I think the TUTATSA says that a limit on renewals introduced after this date may not affect expectation of renewal. Now that's a little bit vague, but basically that's the civil servant saying you shouldn't introduce a 5-year limit to stop people ever qualifying for the indefinite contract.
So there's no legal obligation for them to sort of say, listen, by the way, this has changed, please read
Well,
this
this is
very
all
carefully."
civil law, so if you took it to court and pointed out that this was introduced after that date, purely for the point of view of evading that law, then yes,
Okay.
you could potentially win that in court. You'd still have problems with expectation, though, if you're part-time. That is a little bit of a problem, which we're fighting a court case over this now at Osaka Shoei High School. But here again, we're hitting this thing of expectation.
Is there a difference in this between people who were actually hired before the legal change and then had a new limit introduced on them versus people who were hired afterward and imposing a limit on newly hired people?
Yes, they could. Newly hired people, the TUTATSA doesn't say anything. If you come in to a workplace, sign a contract with a 5-year limit, it doesn't help you.
So if you're hired with a limit, then that's valid. But if you have a limit, if you're already employed and they change it to have a limit, that's not.
That's right. If you're hired and you've signed a contract that agrees to the 5-year limit, then that probably is going to be, well, almost certainly is going to be valid.
Okay, I'll give a brief report about that. The other day, I went to the negotiation with the central government the other day, along with Dennis. We had a negotiation with Ministry of Health, Labor and Welfare officers regarding that 5-year limit matter. We raised a question like this. We are not saying 5-year limit is completely illegal or unreasonable. We are not saying so. However, on the other hand, if this setting of 5-year limit is completely free, completely accepted, look, 5 years later from now on, you may see all private company has a 5-year limit. It means unlimited term contract. This law is dead after 5 years. Then officer answered, we can understand your point. So there seems to be some, line of division between completely okay and completely no. There should be any line.
There's a gray area.
Gray area. But the last discussion, that's the end of the discussion. So we will continue.
So
That's the actual situation.
they don't like it, it's not good. And the Labour Bureau, if there's advice given, will advise employers not to do this. But whether that would change a judge's mind in a court, we don't know. Right? We'd have to see what happened then. What happens.
Usually, how do you establish that there's an expectation to renew the contract?
Okay, expectation of renewal of the contract. Well, actually, I forgot to mention at the beginning of this that one of the things is number of renewals, but it's not as simple. And that the new law writes that even if you didn't apply for the indefinite contract, the case law before was number of renewals, but it's not as simple as that because they look at. And probably Toshi can answer this better than me. Because I think he understands our lawyers' explanations better than I do. But it's all sorts of factors, part-time or full-time, whether it's an essential job, for a teacher, if there was an ALT, they would have less expectation than a full teacher. The permanence of the job, the importance to the business, I think they're all factors that they would take into account on
So,
that.
for instance, a language school teachers would be essential to run a language school, right?
If a full-time, say somebody full-time at ECC, I don't think there's any question about it, that would be, they would have an expectation of renewal after, say, after several renewals, yeah. A university teacher who's part-time, the full-time, part-time is an important part of it, but it's not as simple as that, is it? But can you remember some of the other points? The reasons, what makes a rational legal expectation of renewal?
Yeah, it's not clearly written in the law like that. However, the approach will be quite natural. If this job, a certain job continues, then that teacher, the performance is not bad, and the teacher wishes to continue this job. It's hard to find the reasonable reason to refuse the contract renewal of this person. That kind of thing is a basic idea. Then another thing, later we will have another next session. We talk. The solution is not only in the court only, not in the court only. Maybe the easiest way will be union. It will be discussed later.
One of the problems is there's two different issues here. One is the reasonableness. So with universities, another weak point is that curriculum change. If they have educational reasons, and that's rational from an educational point of view, they can always justify getting rid of somebody. But that's not the same as this legal expectation. And there's these, I think, quite frankly, I think the judgments are from the 1970s are bizarre. There seems to be no rationale. I think the thing is that the job is not continuing because a Hindi teacher, is it a job that's always going to continue? That was the kind of legal thinking behind it. But if the position is going to continue and they're just getting rid of people and bringing in another, then I think Toshi's right, that there is an expectation. The question is proving that. Like in this, they're saying that our member he's not actually in charge of the class. This one Japanese guy who has to look after 4 teachers at the same time is actually teaching the class. But he's not. He's not. I mean, he wanders in, looks around, see how many people are there, and wanders out of the class.
So what would be an example of an unreasonable reason?
Well, we are, for example, at Osaka Shoin, our argument is the reason is unreasonable because they said we'd have to make you full-time if you didn't make, not full-time, we'd have to give you an indefinite term contract. So it's this law. Because of this law the government has introduced. Now that's unreasonable because it's not motivated by objective business reasons or educational reasons. It's motivated by a desire to evade the law. So that's not legally reasonable. The problem is that you still have to overcome the hurdle of the expectation of the earlier legal judgments. Otherwise we could just get damages rather than reinstatement in the job.
Do they actually have to give an unlimited term contract to anyone who goes over 5 years, or is it only to people who go over 5 years and ask for an unlimited term? Like theoretically, if somebody didn't want unlimited term and for whatever reason wanted to keep going on 1-year contracts, they could still give you 1-year contracts forever, right?
Yes, they could. And still, the safeguards of the other law as well, of expectation, would still
apply, right?
Would still apply. But it's only if you ask for it that they have to give you this. When you make that request, really, although it's the contract afterwards that's indefinite. Once you've made the request, it's very difficult for them to non-renew you. I mean, if you did some disciplinary thing that was completely outrageous, yes, they could get rid of you. But if they could dismiss you in the middle of a limited term contract, yeah. But it's very difficult for them to non-renew once you put that application in.
So, for example, like ECC, what they're trying to do is they're trying to make it, they're trying to make the unlimited part not something that people want by saying things like, oh, if you get an unlimited term contract, then you have to have a retirement age. And if you get an unlimited term contract, then you cannot get pay increases anymore because we're not allowed to change your working conditions anymore.
Which is nonsense.
Which is nonsense. So they're trying to make it sound, they're trying to make it something that people don't want, right? But like Simon said, the thing is, apply or don't apply. Now, we don't know what's going to happen in the future because there's going to be court cases and things like that. But you still have the protection of an unlimited term, of all the court judgments in the past. So, you know, but there's a lot of reasons companies are giving. One company actually told our member, we're sorry, we can no longer employ you because the new law. The new law says that you cannot work past 5 years. Luckily, he was an ECC member in Nagoya that was working in a private school, and he called and said, I thought I heard something different. And I said, yeah, you did hear something very different from us.
I know that ECC is kind of a special case, for lack of a better word, but why would a company want to get rid of somebody that's been employed long-term?
Because
'Cause
they
it's cheaper
want
to hire new
have the
people.
flexibility, and this was the thing with the universities as well. They don't know what business is going to be like in the future. So their argument is that it gives them more flexibility. Whereas if people are on indefinite contracts, they have more responsibility to avoid getting rid of people, particularly people with those contracts. They have to take other measures first. They'd have to ask for voluntary redundancies. They'd actually have to go through other measures before they carry through redundancy. The flexibility, they want flexibility, is the main reason. Does it make any sense in an English conversation school? I don't think it does, because people leave anyway. It's 1 year contracts, people come and go.
Yeah.
So they've got that flexibility anyway. But sometimes businessmen have to be saved from themselves, and they get so worried about giving too much to their workers that they take decisions that are not rational from any point of view. I don't think it is in the conversation schools, which is why eventually ECC will probably cave in on.
And they're already starting to cave in. They're already starting.
I think it's the same reason why most places are starting to outsource as much as they can, outsource responsibility more than anything, just to be guaranteed some dude there, rather than the actual management having to deal with genuine people. They just sort of go to ECC, whoever's outsourced them, just like, you deal with them.
Just to make a more general point on the law, here you've got savage competition. So if a company can get round some law which costs them money, they can steal a march on their competitors, and it's a constant thing to drive down. So businesses are constantly, by that competition, unless they're very rich and very wealthy companies, forced to break the law. You know, the law is a limit. They're constantly trying to get round the law in order to maximise their profits. Where it's competitive, it's a little bit different in education trusts and things like that, because in theory they're not for-profit organisations, but certainly with companies, it's most obvious with the AOTs, the dispatching companies for boards of education, where it's terrible. It's a race to the bottom of the pond there, where they're, you know, you can almost see wherever the competition and the outsourcing takes place, the health insurance vanishes. They're all on these 29.5-hour contracts and things like that.
We'll take 2 more last questions and then we'll go to the next topic.
So very,
That's one of them.
Oh, 3 last questions.
very quickly, in the case of university, to protect their anonymity, let's call them Ichidai. They changed the name of the classes from something like academic English to general English. Can they use that as an excuse to fire people who are hired to teach academic English because, oh, now we need someone to teach general English, not academic English?
They could try, but there's nothing written in the law about them doing that.
Yeah.
So it would depend whether you which side could convince the judge.
I would love to see the argument that this person who can speak academic English can absolutely not speak English normally.
Yes.
I have a few students that could help you out.
So on the bottom of page 29, so does this mean I get a full-time contract? No. The only difference between your current job and when it becomes unlimited is the end date will be removed. We're still part-time.
Yes.
Yes.
Yes,
Still
because Osaka Gakuin's reason for changing the retirement age to 60 was because you are now staff. You're not part-time. You have an unlimited term contract, you're staff. And staff retire at 60.
Yeah.
So that's what they were trying to say. So they can't say that.
The Kansai Gaida have done exactly the same thing. Well, that's a moot point. You see, the retirement age is a moot point. Now, I think there's another thing to the labour contract law, which is next year, the parity provisions come in. And some things on bonuses and that, you've got to have parity between different groups of workers. It's not so clear on retirement age. And, you know, we have made the argument that what kind of crazy logic is this, that, you know, the part-time teachers, you have a lower retirement age than the full-time teachers. It doesn't make any sense there. But the Kansai Gaida as well have used this because their staff have retirement at 60. The Kyoshokuin, the teachers, academic staff have retirement at 65, but their office staff have retirement at 60. Of course, they allow them to carry on working after they're on one-year contracts till 65. So this is the problem with it. But in order to challenge it, I think it's wrong, but it's difficult. As long as they keep renewing our union members to 65, it makes a civil court challenge to it not worth the effort, to be frank about it, which is why, you know, for now they'll probably get away with those kind of things.
Okay, 1 and 2. Let's start right here first.
Okay, you had mentioned near the very beginning of this whole seminar that labor standards will not apply to ALTs starting from this coming April because they will be a certain type of civil servant. Could you explain the concept?
ALTs who work directly for boards of education.
I see.
So if ALTs working for Interact, they'll still be covered by all these laws, but ALTs working directly for Osaka Fu, Osaka Prefecture, or ALTs working, some of our members do, for Osaka City, they won't be covered by this law. Things like the holidays, the new law says that they should follow the provisions of the Labour Standards Law, but the law as such doesn't apply.
Okay, thank you.
For the last number of years, I have always requested that ECC show me my contract somewhat prior to April 1st in the hopes that I'd be able to review it and consider it before signing it. And yet they absolutely refuse to do this. They always pull out my contract and we have the renewal on the last possible day before April 1st. Is there any law governing when contracts should be revealed to employers, or like a timeline of how things should work? Or is that perfectly acceptable?
Well, a lot of universities give us the contracts to sign after we've started the year's work. Is that acceptable? No, but
so in this next coming renewal, assuming I go through the process and become an unlimited term contract employee, if they do this again and they simply drop it in front of me on March 31st and say, here you go, take it or leave it, I obviously will look at some things on the page and go, I don't agree with this, and what am I to do if I don't agree with it and would like obviously to discuss it with the union? Do I walk away from it at that point, or do I simply sign it and then address the situation afterwards?
I would say that's the best answer.
Mm-hmm.
Sign it and okay.
if they give it to you actually on the day like that, if they give it to you before, then it's quite reasonable to say, hang on,
Right.
Let me just go away, talk to the union about it, things like that.
Okay. Which is highly unlikely.
Yeah, yeah. And basically what we often do, you can write in, I don't agree with this, but as an individual that can be a little bit risky if they refuse to accept it with your
Amendments, right.
Yeah, so what we normally do is advise people to sign and get a letter from the union saying our member is only signing this under duress, and it doesn't mean that they've agreed to this point, which
Right.
as a union we're negotiating with the employers.
Okay.
And that is a very good segue into the last section.
But how do you sound it?
Oh, Parisa,
Yes,
sorry, I didn't see it.
So imagine that now I have an unlimited contract. How about my visa?
Okay, does it guarantee a
Oh,
visa? No, but I think it will make it easier to
Okay.
get one.
All right.
Certainly. I think they should, and they have no excuse for not giving you the longest possible visa as well in that case, so would they?